We have one.
Ms. Wheeler, can you turn on your camera and your mic? Thank you.
There we go. Thank you.
We have a touchdown. What's the phrase? The eagle has landed. Okay. This matter is the third case on our docket, entitled Williams versus Fernandez. And Mr. Vesley, I can tell it's been a long time since I've seen you because the beard's new to me. Welcome, and would you like to reserve some time, counsel?
Yes, Your Honor, I'd like to reserve 3 minutes.
Okay, I have it. And let me clear off the other time, or your time would have been consumed in part. We are ready to begin now. Please proceed.
Thank you, Your Honor. May it please the court, I am Brandon Vesley of the Florida Appellate Firm, and I represent the appellant, Errol Williams. Your Honors, I'm not sure if you'd like me to dispense with the facts, but they're very short, so I'll just go over them briefly here. This case is a car accident case, high-speed collision, in which the defendant, Chad Joseph Fernandez, was alleged to be at fault. Mr. Williams filed suit, Miss Williams filed suit against Mr. Fernandez and his father, Christopher Joseph Fernandez, as the vehicle's owner under vicarious liability theory. Fortunately, we don't have the problems that the last case had. Mr. Fernandez admitted that he was the vehicle owner. On December 22nd, 2020, the defendant, Christopher Fernandez, served a proposal for settlement in his name only. On January 7, 2021, 16 days later, the plaintiff accepted the proposal for settlement. And on that same day, defense counsel then tried to set aside the acceptance on a unilateral mistake theory. The hearing on that motion was held on January 25th. So approximately 18 days later, and the trial court granted the motion and set aside the acceptance. This appeal followed. Your Honors, there's 4 arguments that we're going to be making here. The first argument is this was not a unilateral mistake, at least as far as anybody could tell. It was not obvious that there was a unilateral mistake, but rather it was very clear and unambiguous that this proposal for settlement offer of judgment was enforceable. And the proposal for settlement was very specific. There were no ambiguities in the proposal. It was not simply a clerical error like transposing numbers or adding a 0. Chad Joseph Fernandez was excluded from the proposal for settlement, and he was excluded from the notice of service of the proposal for settlement. And that's very important, Your Honors, as you'll see in a minute. There was 6 different opportunities on the proposal for settlement.
Mr. Vesley, can I, Mr. Vesley, let me see
Yes.
if I could kind of cut to the chase. We all agree the proposition that in Florida, and I'm quoting from the case, that a contract can be set aside, which in this case, we could argue this is a contract on the basis of unilateral mistake, unless there's 2 exceptions. Number 1, the mistake is a result of inexcusable lack of due care, or B, the other party has so changed its position and reliance on the contract that basically the rescission would be unconscionable. We could all agree that the sub B doesn't really apply here. Is it your position, Mr. Vesley? And I think this is where I'm leading you to, because I want to be able to talk about that. You're taking the position, as I review your brief, is because of all the entries that they made, and to quote you, that 6 different times, 6 different mistakes, you're taking the position that the exception under A would be that this is the result of an inexcusable lack of care. Am I understanding you correctly?
Yes, Your Honor, that is one of our arguments, but it's not because we recognize that there's 6 different entry points for them to include the father in the proposal for settlement. The reason why we're saying that is because it's their burden. It's the defendant's burden, it's the defendant's counsel's burden to prove that it was not inexcusable neglect. And they didn't prove their case. They had a hearing on the 25th. There were never any affidavits presented. There was never any sworn testimony given. And all we had was an attorney saying what other people told her. And that is not evidence under Passport Leasing Corp versus Zimmerman, the Faircloth versus Bliss case. These are cited in my brief. I can give you the citations if you want them. Unsworn statements by
And
attorneys.
there's no need, Mr. Vesely. So if I may, Mr. Vesely.
Sure.
And I know your brief has all of that. So let's go to the hearing. You're taking the position that at the hearing, they needed to provide sworn testimony because the lawyer basically said, here's what happened, here's what happened, here's what happened. And so when the lawyer was making that recitation, was there any objection from the other side saying, Judge, they need to provide, evidence, you need to swear that lawyer under oath, they need to provide, was there any objection made at the hearing itself?
I don't believe there's any obligation to make an objection. Sure, there was not an objection made, but there's no obligation to make an objection to a party not proving their case, Your Honor. They have an obligation to come in there, it's their burden again, and they have to prove that they have the evidentiary support to back up their claim, and that claim is that it was a mistake. And they have no affidavits. She talks about all these different participants in this, the IT department, her own judicial assistant, and her own statements. She didn't make any sworn testimony. So all of these, all this information came in without any proof whatsoever. And Your Honor, that's simply unacceptable.
All right. Was there any stipulation by the parties that this is how the hearing will go? Was there any understanding before the hearing that this is just going to be argument and let the court decide? Any of that type of thing?
None whatsoever, Your Honor. And it has to be a stipulation between the parties if you're going to have the attorney's statements come in as evidence, and there was none. And Your Honor, let me point out something as well. So most of their brief and their case is about how this proposal for settlement contains all these editorial mistakes, and that's proof that this was wrongly prepared by Ms. McCurdy. Well, and she says she never looked at it. She never looked at the actual document after she put it into the IT department system, and it was signed by her assistant, and it was sent out. Well, there's also the notice of service of proposal for settlement. If you read my briefs, you recognize that notice of service of proposal for settlement actually has all of the editorial changes that she's claiming she should have made. And if she's correct, would have contained the name of Chad Fernandez, but it didn't. It just contained the name of Christopher Fernandez. So what does that tell us? Either Ms. McCurdy is allowing her assistant to prepare a notice of service of proposal for settlement and send it out under her signature without ever reviewing it, or she prepared it herself. So we have a real problem in this case, because what we have here, Your Honor, is somebody who's coming back after the fact and saying, I didn't look at any of this stuff, and please let me off the hook for all of it. That's inexcusable neglect, Your Honor.
But Mr. Vesely, I'd like to touch upon the excusable neglect part of the argument. Correct me if I'm wrong. There is no excusable neglect exception under either the statute that deals with proposals for settlement or the implementing rule of civil procedure, correct?
That's correct. It's case law.
Unlike final judgments, there is no excusable neglect way to get out of a proposal, and it's a creature of statutory law, correct?
Yes, the case law has created an exception.
Well, okay, and that's what I wanted to get into. This exception arises under the unilateral mistake exception that has kind of drifted over from an exception to contract formation into proposals for settlement, correct?
Correct.
Okay. What are your thoughts on, and to some extent the ship has probably sailed on this, but I'm curious about what your thoughts are on whether or not it's a good fit to try to liken contract formation, which we usually think of as a legally binding agreement between two people who are free to negotiate and walk away without any adhesion. How does that graft into the statutory framework for proposals for settlement, where we have statutory deadline imposed that says if you don't respond, you're deemed to have denied it, and a potential attorney's fees hook if you improperly refuse it? Is that a perfect match?
And it's a horrible fit, Your Honor. It's a horrible fit because in our situation, we had what was, appeared on its face to be a very valid settlement proposal. And my client took 16 days to review it and think about the consequences of that before she accepted it. And that's plenty of time for Ms. McCurdy to figure out that it's incorrectly presented. But regardless of that fact, it's a horrible fit because now we have what could be used in gamesmanship as something to hold over my client's head and possibly get attorney's fees if we don't get the numbers that we're looking for. Or at the, and if we accept it, then they can say, well, we screwed up. We made a mistake. It was meant to be both of them. So I don't see how you can, under a public policy theory, affirm this case. This is a true problem. And you're right, Your Honor. It really shouldn't be an exception to it. You made the proposal. Now, if it was a clerical error that a secretary did, and you presented an affidavit that the secretary made the mistake, then I think there are exceptions for that type of a mistake. But that's not what happened here.
Well, here's the thing. It's I kind of see it as an all or nothing argument. You're either all in on that or we can have exceptions. It's either the statute and the rule control within their four corners of what they say, or we start bringing in these extra textual allowances and exceptions from the law, and we kind of just pick and choose which ones from different areas of the law that we want to bring over. We've apparently brought over the unilateral mistake one, but I mean, I think the answer to that issue about whether it's a secretarial mistake, I think the answer would be, well, call your legislator and tell them to change the proposal for settlement statute to allow a clerical mistake exception, because it's not in there now. That's my understanding. But I mean, are you saying no, that should be something that should be allowed?
No, Your Honor, I agree with you. I'm saying if you're going to look at the exception that they're trying to create, then you would need to have somebody like, if you're going to look at their exception, you're going to say that's a valid type of exception. You would need the secretary to come forward, not the lawyer to say the secretary did this. And that's what they're trying to get away with here. So, but I agree with you, Your Honor. It puts us in a very precarious situation. It makes it very difficult for my client to determine what is the right thing to do here. And, like I said, she took 16 days to figure it out. She didn't jump on this the next day thinking, aha, we got you. It wasn't like it was clear from the offer of judgment that this is something that she should take, was not like some windfall for her. And in the other case that the court cited, it's the Maryland Casualty Company versus Krasnick. And that's the case that the court cited in her ruling. In this case, it was a clear windfall because after they realized that they had made this proposal for settlement, they also realized that they didn't actually owe any coverage on the vehicle. So this became a windfall to the parties. Our case isn't like that. Our case, my client had every right to accept a $17,000 offer for proposal for settlement as to one of the parties. And, it is common for the vicarious liable person to want to get out of the case, especially if they have deep pockets and the insurance coverage isn't sufficient. That's a big problem in a case like this. So, it makes sense that they would make that offer. So, Your Honor, let me continue on with my argument, unless there's any other questions on that. So we argued that it wasn't a unilateral mistake initially, and then going past that, we argued that obviously there was not an inexcusable lack of due. There was inexcusable. It's complicated. There was inexcusable lack of due care here. That they had an opportunity. When this motion was first drafted, January 7th, the trial counsel filed a response on January 11th, and it cites the Passport case, and Passport tells the parties what they need to do if they're going to try to set this thing aside. And that says you got to bring in testimony. You can't just or affidavit. You can't just rely on what the trial lawyer says. And of course, she had an opportunity to read that, but of course she she didn't bring anything. There was no affidavits presented from any of these entities that had an impact on this supposed unilateral mistake. So we cited the cases of BMW versus BMW of North America versus Crathon, 471 Southern 2nd 585, Florida 4th DCA case, and Passport Leasing Corp versus Zimmerman, 945 Southern 2nd 660. In each of those cases, the court found that the mistake resulted from inexcusable lack of due care. And those cases are very similar in concept to this case. In BMW of North America, the car dealer's failure to include in the offer of judgment a condition that the buyers actually return the vehicle to the dealer was considered a unilateral, and they argued that was a unilateral mistake. The court found that was inexcusable lack of due care. And in that case, the court wrote, the facts in this case at bar provide ample support for the trial court's finding of inexcusable lack of due care on the part of BMW's counsel. The offer of judgment did not involve a complex transaction, and neither does our case. The terms were few and easily understood, and they were in our case. Thus, the omission of what is now claimed to be an essential term cannot be characterized as a minor inadvertent error. I mean, obviously, leaving out Chad Fernandez is not a minor inadvertent error. On the contrary, it evidences a total lack of forethought and poor draftsmanship as to the well below accepted professional standards. Accordingly, the trial court is justified in refusing to grant relief from the unilateral mistake, which resulted from inexcusable lack of due care. I mean, that's what we have here, Your Honor. If indeed the argument is going to be that this thing was prepared wrongly, it was due to poor draftsmanship, poor overview by the attorney who was allegedly letting her secretary sign these documents and send them out. And she has an obligation to do that. So how can this be considered excusable lack of due care? It's inexcusable, Your Honors. And in this day and age, when everybody is using electronic signatures and using remote access to their offices, it is extremely important for someone to come forward and say, look, we're not going to look past our obligations as attorneys and our responsibilities to make sure that we are doing things that our attorney overview is in control of. You can't just have—
You are at 17 minutes.
Okay, Your Honor. Lastly, Your Honor, we did talk about the public policy and how this impacts clients like mine. To allow this conduct would invite parties, plaintiffs or defendants, to submit valid, erroneous proposals for settlement in the hopes that later of obtaining attorney's fees and costs following entry of a favorable judgment, but be relieved of the valid, erroneous proposals if they're accepted. And Your Honors, that needs to be pointed out and needs to be quashed before it happens. Your Honors, I would ask the court to reverse this ruling, allow the proposal for settlement properly accepted to stand. Thank you. I'll save the rest of my time for rebuttal.
Attorney Wheeler, you may proceed.
Thank you, Judge. Your Honors, I have to point out that Mr. Vesely ignored the standard of review that's applicable in this case, and that standard of review is abuse of discretion.
Following that, Ms. Wheeler, if I may.
Yes.
What troubles me, and help me out, and I'm jumping into the actual hearing itself. Usually all the cases that have been submitted, there's been testimony, there's been evidence presented. What troubled me here is that you just had a lawyer just making statements to the court about what transpired. And if you're going to be setting aside an agreement that was accepted, why wasn't there? A lot of the things Mr. Vesely said that there were hearsay statement. This is what occurred. It's a computer problem. It's my secretary's problem. It was a new thing. and not testimony, her statement, oh, I should have, from now on, I'm going to start reviewing before I send anything out. Shouldn't there be sworn testimony presented in order for the court to hear and then subject to cross-examination to make the determination whether or not this truly falls as to one of the exception of excusable as opposed to inexcusable neglect?
Well, Your Honor, I would point out two things. Number one is there were several times during her presentation, if you want to call it that, that Ms. McCurdy made her statements as an officer of the court. There was absolutely no.
Let me interrupt you, Ms. Wheeler, because back in the days, and I'm sure Judge Casanueva as a former trial judge and Judge Lucas as a former trial judge, it used to be lawyers would come in even for fee issues. You're an officer of the court. Things have changed. Now the cases have changed where regrettably you can't just simply say as an officer of the court, there has to be testimony. And I appreciate what you're saying because, you know, this is what you mentioned in your brief, but there's some cases that say that's not sufficient anymore.
But in this case, Your Honor, there were no objections to her representations as an officer of the court, and everything that she related was within her own knowledge. If she had been placed under oath, she would have been saying the same things.
Well, but let me interrupt you right there. You said there was no objection, but isn't the burden, I mean, right now the burden is really upon her to provide evidence to the court. And so if somebody decides to not object, maybe they're thinking, okay, they're not going to be able to, she's not going to be able to prove because based on her stuff, she should have testified, she should have brought in witnesses. I'm just going to sit and let her go on with it because she bears the burden and she has not met the burden by failing to provide all of this information.
And Your Honor, I would say that that would be the ultimate gotcha type of an argument because they made no objection. And remember, Your Honor, too, that this was during the time of the pandemic when everything was being done remotely. And there was no one else who could have provided the information that Ms. McCurdy provided because she was there. She knew what happened. She was the one who experienced the problems. And
but she couldn't be easily done. Like you bring in subpoena of her secretary and the secretary could testify to the fact, oh yes, I was working on one document and then there was another document. Or she kept saying it was a new computer, the computer somehow, somebody from the IT people to testify. This was a new computer. It's bizarre what occurred. Just something just to prove the generalization or her statement that she said, because again, she's saying my secretary did that, things of that. These are out of court statement. These are hearsay statements.
Well, and Your Honor, I would again point out that there were no objections. I've gone to that transcript and I've gone back to the index at the back to see if the word object was in the index, and it isn't. So there were no objections made.
There was a reference on page 62 of the record where counsel said, about our conversation, there's no affidavit, but I don't know if the word objection appears there, but there was a mention of an affidavit limited to the context of the two counsels' conversation, if I recall correctly, and counsel for the appellant below would have said, I disagree as to the content of our conversation. I think there's a couple down the lines there. He says, well, she's honest, but obviously there was some dispute going on. And I'm not certain that anybody asked to be sworn to cross, but it was disputed. And I'm not sure that you can say to be testimony, as Judge Kuzan pointed out, because no one went under oath. But there was at least an evidentiary call about there's a lack of an affidavit. I believe that was the right page, but don't bet on my recollection of the exact page number.
Well, again, Your Honor, I think that an affidavit, again, is not subject to cross-examination. Ms. McCurdy was there. She could have been asked questions by.
And counsel could have asked to have her sworn in. I understand.
Yes. And for them to wait until after the fact. And, I just think that their objections are too little too late, because there was no contemporaneous objection. And we cited some cases in our brief talking about lawyers making statements as officers of the court. And certainly I think that it's supported historically that a lawyer may do that. And if there was an objection at the time, then the judge could have sworn her in over the internet, I guess. I don't know how that would have happened, but there was no contemporaneous objection to her representations as an officer of the court.
Well, unpack that a little bit, because, okay, let's assume for a moment, it's a no harm, no foul situation. Did we ever get a definitive statement of what you refer to it as the problem, what the problem was, other than it came out wrong? Did we ever get, usually in these cases of excusable neglect, we get, the dog ate the homework, or, the thing got misfiled, or what have you, or it got buried under a stack of papers. Did we even get that in this case?
I know it was corrected. Whatever the issue was, it was corrected after.
So that's my question.
Occurred.
Whatever the issue was, I'd like to know, what was the issue?
And Your Honor, I'm sorry, but I wish Ms. McCurdy was. She may be listening in on this, but I don't know. I'm not in that office, and I know that it has been corrected.
And if you don't
Whatever
know,
it was,
neither did the trial judge.
Pardon?
And if you don't know after reviewing the record, then neither did the trial judge at the time of the hearing.
Correct. But understand, Your Honor, this occurred, this proposal was served on December 22nd. This is something else that I would like to point out. It was served by computer on December 22nd, and which I think was on a Wednesday of last year. So in between, he says that they waited for 16 days. Well, in that 16 days, we had 2 long weekends. A lot of law firms may have been off for 2 extra days. They may have had 8 days off. Most law firms.
But if I may, Ms. Wheeler, that argument, it was Ms. McCurdy herself that chose to send it on that day. So the argument that, okay, it happened on the 22nd, for some reason she chose to send it on that day.
No.
And so for me, that doesn't,
Your Honor,
that doesn't really answer or doesn't really support the position that, that there were long weekends. I don't know that.
Your Honor, I make the point because he says that they had 16 days to accept it, but I think that it was really actually less time than that, because of the fact that there were long weekends. And I think that the fact that they jumped on it just indicates that they were aware that there was a mistake. And they wanted to take advantage of the fact that only one offeror was identified and take the $17,000 and continue to litigate where.
Or Ms. Wheeler, they just wanted to make sure they stayed ahead of deadlines on a statute that potentially imposes attorney's fees if you wrongfully accept it, which kind of, if you fail to accept, which segues into my question. I pitched it to Mr. Vesely, and I'll pitch it to you as kind of a sauce for the goose, sauce for the gander argument. You spent some time talking about excusable neglect, putting aside that there doesn't appear to be any statutory or procedural rule bases to bring this notion of excusable neglect. Let me ask you this: what if a plaintiff's attorney were to come along and say after the fact, "Hey, I talked to my client about a proposal for settlement that the defense had served. She accepted. I transmitted instructions to my legal assistant to accept the PFS, but whoops, a computer glitch happened and we didn't get the acceptance out within the 30 days." But it was excusable neglect, so we shouldn't be held liable for the defendant's attorney's fees at the end of the day. What would your response to that be? Should they be able to pitch that to the trial court?
I think there are 2 different issues, Your Honor, because you're talking about at the end, at the deadline issue, as opposed to whether this was not a situation where there was a problem with a deadline approaching. As I said, and he's admitted, they accepted within 16 days, and within that 16 days, there were at least 6 days that were holidays. where there was nothing going on. So, and I've been doing this a long time, Your Honor, and I have never seen myself a proposal accepted quite this quickly. And I think that they recognized that there was a problem. Everything before had
you're trying to read tea leaves there. Then that's not in the record, and I'm not sure. At least
maybe,
speaking for myself, that's very helpful.
well, Your Honor, I just know that there were a bunch. We identified a bunch of, we call them red flags in our
Yes.
brief, a bunch of issues with this proposal. It was obviously a mistake, and I think that you know, the judge saw that, and she, I thought, gave a reasoned opinion. It was based in reason, and the standard of review here, I would remind the court, is abuse of discretion. And the cases that he cited, the passport leasing case, no abuse of discretion. The BMW versus Creighton court, no abuse of discretion. These are, you know, whatever the decision was by the trial court was affirmed because there was no abuse of discretion. And here, I think that the court needs to keep that in mind. The Tobin case, which is cited in our brief, in that case, U.S. Alliance discovered after an OJ was accepted that its driver's name was inadvertently omitted from the written offer. And the third DCA set aside that offer of judgment because the error was inadvertent and known by Tobin's counsel when the offer was received. And I think that everything that had been previously filed by the defendants in this case had been filed by both of them. And remember, this was a case where the father and the son were jointly liable for the damages. So why in the world is there a reason for there to be only one of them to be released in the event that a proposal for settlement is accepted? The purpose of the proposal.
But Ms. Wheeler, that argument for me, I've seen a number of cases where strategically, where the insurance decides to settle one and not the other. So, you know, that for me did not raise any concern, but I want to give you an opportunity to address something that Mr. Vesely said before you run out of time. How about the issue of the gamesmanship, where if someone would handle it purposefully by, let's do this, and then we could always set aside later on. I want you to have the opportunity to address that really briefly.
Well, number one, Your Honor, there was just no evidence of gamesmanship in this case. Always before, everything that had been filed by these defendants had been filed by both of them. There's no indicator of gamesmanship here, except that that's the way they're trying to get out from under the fact that they accepted if you want to call it a faulty proposal. I don't know that I've answered your question, but I can assure the court that there was no gamesmanship intended.
Let me phrase the question differently, and it's unfortunate you are in this position perhaps rather than the other position. But I can remember a case called Lucas versus Calhoun, where writing for this court, I mentioned that the purpose of the offer of judgment proposal of settlement is to end judicial labor, not cause more.
Correct.
If I tie that to what Judge Lucas was suggesting earlier, that this is a statutory procedure implemented by a rule for the benefit of the court and arguably the taxpayers, perhaps then there is no neglect. You either comply or you don't comply with the rule. And if you fail to comply with the rule, then the relief you may have to get is from your legislature or from your insurance carrier. But that this is not anything more than the implementation of a statutory thing that is supposed to end judicial labor and not create more, and thereby avoid gamesmanship.
Your Honor, I'm not sure if I'm answering your question.
You know, I've been on this podium for a while.
Well, I would point out to the court that there are two cases that they cited in their brief saying that these are just examples that people make offers on behalf of just one of the parties a
But
long,
if we
a long
put in
time
a
ago.
bright line rule saying there are no excuses, we will then make sure that the lawyers do what they have to do, double check, triple check, and judges won't have to go whether it's excusable or not, and will not have to be confronted down the road with the argument that maybe somebody's playing games here. I mean, it makes it a very clear black letter rule, you know, in my days of law schools, sufficient to be in Gilbert's or whatever the other outline companies were.
Well, Your Honor, I just, I'm not sure I know how to answer your question except to
Yeah, that's probably
remind
fair.
the court, if I could just remind the court that in 2010, I think it was, the Supreme Court revised the offer of judgment rule to say that before that, people were having to separate out because if only the owner made a proposal or the driver made a proposal, then it was considered invalid. But the rule was amended in 2010 to say that it was not necessary to separate out the parties if they were alleged to be jointly and severally liable. I think that's subdivision C4 of
Yeah, and you might
1.442.
cause me to be cause of that because I wrote USAA versus Bahar and had a husband and wife offer, and I said the wife had a right to take a look at it and not be lumped together. I understand. Yeah.
So the rule did not require apportionment between an owner and between a driver and
I'm just saying there may be benefits of a clear black letter rule based on a statutory vehicle, as Judge Lucas was asking about at the beginning of this presentation, I believe. I'm not
well,
saying that it's going to happen. I'm just saying there are some benefits to it.
well, there are, and the court recognized that there was a benefit to having a provision in the rule that says that when you're vicariously liable, you don't have to separate out because it's impossible to separate out the liability.
That kind of proves the point, doesn't it? That if there's a problem, you amend the rule or the statute, and then that can address it. And the competing interests can be weighed.
But that was done, and
Right.
what would have been done if the correct proposal had been filed, and this was a computer glitch, which we all know happens. We had it today at the beginning of this argument. I had a computer glitch getting myself logged in, to tell you the truth. They happen, and unfortunately, we don't know when they're going to happen. And despite the fact that we've been through this same experience before with no problems, who knows when the glitch is going to occur or what it's going to be. But there are going to be glitches, and that's what happened in this case. And it's undisputed that there were glitches, and the judge recognized that. She accepted it. She did not abuse her discretion in setting aside this acceptance. And I don't know if my time has expired.
You have 30 seconds or 45 seconds, right around there, going down.
Well, I just would remind this court of your decision in the Love case, where there was a clerical error. A proposal went out for $215,000 and it should have been $115,000. And they moved to set it, it was accepted, of course, at $215,000. The defendant moved to set it aside. The trial judge granted it, and this court affirmed. It said it was a clerical error. And that's what happened in this case. It was a clerical error. And it was obvious, I believe, to the other side that it was a clerical error because everything had been filed on behalf of both of these defendants. It was a father and son. The father was vicariously liable. There was no reason for there to have been an effort just to get one of these defendants out. No reason whatsoever. No reason has been cited. So with all that, we respectfully request the court to affirm.
Thank you, counsel. Okay. Mr. Vesley, you have 2.5 minutes remaining. You need to unplug, sir. You are muted.
Sorry, can you hear me now?
Perfectly. Thank you.
I hope I didn't eat my time up doing that. First of all, Your Honor, she said it's not within their was not within their that it was not within their knowledge, her own knowledge. It was not within their own knowledge, meaning that she was well aware that it was an IT issue. She was well aware that her secretary was signing her name and she wasn't reviewing the documents. She was well aware that there was some software problems, and yet she still presented no affidavit.
Is she aware there was this problem in this before or after this pleading went out?
She claimed there was a problem with the software before at the hearing, which again is not evidence, but she claimed there was a problem with the software before, and she claimed, and then at trial, she never said what the problem was because she said she still didn't know. Okay.
So your argument is that she was aware of a problem and she was alerted to it. So she should have spent more time proofreading it and checking it before it went out, so that her neglect is not excusable.
Your Honor, under 2.515, the Rules of Judicial Procedure, we have an obligation when we sign our names to documents that are going out that we proofread them. She didn't proofread any of these documents. It's inexcusable neglect. She needs to own it. The issue was never presented to the court as to what the problem was. In the Tobin case, just to clarify, that case, they actually had a settlement negotiation. All the parties sat down. They talked about the settlement. When the actual agreement was presented, it was contrary to what they talked about. So obviously they knew about it. It was a totally separate situation. We had no knowledge that she was going to be presenting the proposal for settlement as to one party, but that's what they did. So that's what we had to consider. And 16 days is a long time, Your Honor. 16 days is a long time. You can't expect her to be able to say that my clients didn't present it to their client within, timely. It was presented to them. They thought, she had ample time to review it. So that's not a nonsense argument. And the bunch of issues in the proposal for settlement, we point back to the notice of serving proposal for settlement. All of those issues were presented in the notice of service proposal. So either Ms. McCurdy drafted that herself and intended to only list one party, or she let her attorney draft that thing and send it out by herself. Okay. So this is, Your Honor, this needs to be reversed. I greatly appreciate your time. And
thank you both for your presentation today. On behalf of the panel, please stay well. And what's this thing? We will see you again next time. And we'll let you all take a break to be transferred over. For those that are listening in here, we are going to take a recess after this case. We have 2 more remaining. According to my clock, it's about to be 11:43. So we